Good afternoon. As you all know, I'm at Jacksonville State University working on my certificate for instructional leadership. And so I've got my PowerPoint presentation that I was partnered with Brian Thorpe. We pieced this together, and it's legal and ethical issues in education. And so I've got three of my peers that are with me, and I will let them introduce themselves before I get started.
John Thornton.
Hey, I'm Mary Hall.
Jessie Stark, third grade.
Alrighty, now I'll begin with the presentation. So our introduction, basically, the purpose of our presentation is to discuss legal and ethical issues and the effect that they have on education. We will discuss several topics throughout this presentation. The issues of discussion will be issues concerning religion in public schools, freedom of expression for students, student protests and demonstrations and censorship of student newspapers, search and seizure, due process, liability and student records, individuals with disabilities, and the Alabama Educator Code of Ethics. Religion in public schools. The Bill of Rights is separated church and state. The First Amendment has two essential laws that are regarding religion. The Establishment Clause basically prohibits the state from passing laws to aid or show favoritism for a particular religion, and the Free Exercise Clause prohibits the state from interfering with individuals' religious freedoms. And anytime you guys want to chime in, just feel free on any of the topics. State encouragement of regular recitation of prayer in the public school system is unconstitutional. So that just means basically before school each day, you cannot require your students to, go in with a prayer. It cannot be required. Direct reading from the Bible is not allowed in public schools. But if you're using it as a teaching resource, then of course you can allow the Bible as far as in your classroom. The observance of any holy days by public schools are unconstitutional if it's conducted in a devotional atmosphere, which basically means you can't celebrate that holy day and kind of make it be a church-like atmosphere.
Did you find out when you were reading this that, did you read anything about students bringing the Bible to school? Because I could have had that and always
Yes,
thought that was fine.
and I think it's on another one of the ones coming up, but students can pray to themselves, not in a group, but they can pray to themselves, or they can bring the Bible and read it to themselves, but they cannot share. That's their thoughts. Private and voluntary prayer by a student is permissible under the Free Exercise Clause of the First Amendment. So that's kind of what you just asked. But personal or philosophical differences should be avoided in deciding whether religious clubs are granted access to facilities. That means you cannot discriminate, and so you need to leave your personal biases out of it. School districts are obligated to allow religious groups access to facilities if other non-religious groups are permitted to use them. For instance, if with our gym downstairs, if the Huntsville City Schools decided to allow my family to have a family reunion or anything along those lines, then even if there was a religious group that they did not agree with their beliefs, they still have to give them the opportunity to use the facility. The religious rights of teachers must be represented as long as the Establishment Clause is not violated. Freedom of expression for students. This talks about student protests and demonstrations and censorship of student newspapers. This one was pretty interesting because it had a lot of stuff that I had no clue about. Not that newspapers in the schools are, kind of non-existent, but we're kind of going away from them with different newsletters and different stuff. So the students have kind of, with all the digital technology, students have gone kind of away from school newspapers. But the First Amendment guarantees freedom of speech to U.S. citizens, including students in public schools. So almost kind of in essence, you can kind of say almost what you want in that newspaper. It's a fine line in it. Protests are considered forms of free expression, so students are allowed to do so, but school officials can regulate the time, place, and manner. So basically, if your students disagree with something, then they could have a small protest, and from what I gathered in the book, Dr. Wallace would kind of have to let it go because minor disruptions must be tolerated. Like it's slippery slope. If they decided, hey, tomorrow at 3 o'clock, we're gonna stand up and do this, or we'll just say 2 since we're still in school, we're gonna do this, then basically Dr. Wallace could regulate the time. If she said, hey, 2's not a good time, then they could do it at 1. And then the place and the manner, and of course you expect no fights or anything like that, but you expect for minor disruptions, kind of maybe a little arguing, bickering, going back and forth for some things. Student writers must adhere to the rules of responsible journalism at all times. So basically, the final editorial decisions are with students and not the teachers. So students cannot just report a bunch of junk that's not true. There are certain things that they cannot say, but they're held accountable the same way as someone that's writing an article in a newspaper. And the teachers basically that are over those newspapers are supposed to do grammatical corrections, things like that, not absolutely completely take something out because it kind of lays in the student's hands, if I don't say so does. Broad censorship by school officials is not permitted and is a violation of free speech for students. But the limits on that include vulgarity, religion, origin, and race. Like there's certain topics, like if you cannot attack a certain student due to their your difference in beliefs. Search and seizure. This one was kind of interesting too, because I'm assuming that we all want to go home safe the same way that we arrived. But as I learned, it has its own kind of little set of laws. The Fourth Amendment provides protection against search and seizure for all citizens, and rights should not be violated, but upon probable cause. All right. So that just kind of means that you are really not allowed to do it unless it is justified. If you see a gun or a knife that is poking out, that gives you probable cause. School officials need only reasonable suspicion to initiate a search. Once again, students do have their own rights for search and seizure, but if you have a reasonable suspicion that maybe there were some threats made, someone was going to bring a weapon to school and do certain things, and you see something poking out of their shirt or in their pants, then that gives school officials the reasonable suspicion to initiate the search. There has to be a balance between maintaining order, discipline to protect health and safety. And so that basically means that there's a fine line of the things that the students are allowed to do and as far as the search and seizure that the administration, teachers, and the RSO officers have. The primary purpose for the search should be to secure evidence of student misconduct for school disciplinary purposes. So, like I said, that goes back to, once again, the school just can't randomly pick somebody to search. It has to be a justifiable cause, reason for them to search that person. An arbitrary search or mass shakedowns cannot be justified and are illegal. That just means we can't randomly take everybody in 5th grade and shake them down, because that is against the law. Due process, all right? Due process affects us, of course, in education, because if something happens to where a questionable call is made as far as in our classroom or something else, and then the city of Huntsville decides that they might want to terminate our employment, then we get to go through due process. The due process clause of the 5th Amendment applies to the federal government, whereas the 14th Amendment applies to the states. The essential focus of due process is fundamental fairness. We all want the opportunity to be treated fairly, of course, before somebody terminates our employment. There is a procedural due process that guarantees that a prescribed set of steps will be followed, that allows students and school personnel an opportunity to seek redress for alleged violations before any action is taken against them. And then there is a substantive due process. It ensures that a valid reason exists before an individual is deprived of life, liberty, or property, and that means used to achieve this objective are reasonable. All right, so now we're on to liability and student records. As you all know, student records are kind of private. For instance, you all teach 5th grade. You have no reason to be looking at a 3rd grader's record. But the difference is your homerooms, as far as I know, I think you all switch classes, so then there'll probably be 2 sets of student records that you'd have access to. Public Law 92-380 The Family Educational Rights and Privacy Act, to do it, FERPA, protects confidentiality of student records. So like I said, that's just so people are not violating students' rights going all through their records. When consent is necessary to release student records, it must be provided in written form, signed and dated by the consenting person. That's plain and simple. It's gotta make sure it's got all the signatures, all the T's have to be crossed, the I's have to be dotted. Teachers, counselors, and administrators who have a legitimate educational interest in viewing records may do so. Once again, that goes to you all. I think we start even in third grade. I think you all switch classes. So that means that rightfully you have the right to, I think, depending on how many classes you all switch, but at least 2 sets of classes, your homeroom and whatever teacher that you switch with. Accurate records should be maintained in the student's file, indicating the name, title, date, description of educational interest, specific records examined, and the place of the examination of student records for those who have access. Individuals with disabilities. It affects each one of us as far as our classroom specifically, but individuals with disabilities are protected by 3 significant federal statutes. IDEA, which is Individuals with a Disability Act, the Americans with Disability Act of 1990, that's ADA, and the Rehabilitation Act of 1973, which is Section 504, I think. I'm pretty sure that we've all had some students with some 504 plans somewhere throughout our teaching careers. Student disabilities. School districts should ensure that children with disabilities in their districts be provided equal access to public education. Everybody has to be treated fair and equal, guys. Children with disabilities should not be disciplined for behavior that is associated with their known disabilities. That's a slippery slope, but the law says it, so we kind of have to make sure that we follow and we abide and give them a fair opportunity as well. School districts may be required to provide educational services beyond the regular school year, typically referred to as extended school year services, or ESY. All right, and so now we are to the Alabama Educator Code of Ethics. It has 9 standards. The first one is professional conduct. The second one is trustworthiness. The third is unlawful acts. The fourth is teacher-student relationship. The fifth standard is alcohol, drug, and tobacco use or possession. The sixth is public funds and property. The seventh is remunerative conduct. And the eighth is maintenance of confidentiality. And standard 9 is abandonment of contract. The description. A code of ethics represents a standard of behavior that is accepted by a profession, an organization, or a corporation. The Alabama Educator Code of Ethics defines the professional behavior of educators in Alabama as a guide to ethical conduct. The code protects the health, safety, and general welfare of students and educators, and it outlines objective standards of conduct for professional educators, and clearly defines actions of an unethical nature for which disciplinary sanctions are justified. Standard 1, professional conduct. An educator should demonstrate and conduct a conduct that follows generally recognized professional standards. Some examples of ethical conduct: educators participating in ongoing professional development individually and collaboratively to promote student learning. Additionally, they share their knowledge and learning experiences, basically kind of mentoring people, different things like that. And then an unethical example of that would be failure to provide appropriate supervision to students, physical and verbal altercations with colleagues and students, and a violation of test security for district and standardized tests and test materials. Standard 2, trustworthiness. An educator should exemplify honesty and integrity in the course of professional practice. Ethical example, be advocating for fair and equitable opportunities for all children. Unethical will be falsifying, misrepresenting, omitting information involving job duties, students, and personnel. Standard 3, unlawful acts. An educator should abide by federal, state, and local laws and statutes. Ethical example would be communicate high expectations to students and encourage and promote positive behavior in the school and community. Unethical conduct, inappropriate relationships with students, colleagues, and parents at school and the community. Standard 4. Once again, guys, if you got anything, you can chime in. Standard 4, teacher-student relationships. An educator should always maintain a professional relationship with all students, both in and outside the classroom. Examples are ethical conduct would be creating, supporting, and maintaining a challenging learning environment for all students. Unethical example would be engaging in harassing behavior on the basis of race, gender, national origin, religion, or disability. Standard 5, alcohol, drug, and tobacco use or possession. An educator should refrain from the use of alcohol and or tobacco during the course of professional practice and should never use illegal or unauthorized drugs. So you shouldn't have any drugs that are illegal or even legal, but as long if they're not yours, that makes it illegal for you to have them. Ethical conduct example would be factually representing the dangers of alcohol, tobacco, and illegal drug use and abuse to students during the course of professional practice. That means you basically just giving them just say no to drugs kind of thing. An unethical conduct would be being on school premises or a school-related activity involving students while documented as being under the influence, possessing, or consuming alcoholic beverages or tobacco. Standard 6, public funds and property. An educator entrusted with the public funds and property should honor that trust with a high level of honesty, accuracy, and responsibility. Guys, if they put, the public funds in your hands, you cannot have the misappropriated funds. Ethical example would be maximizing the positive effect of school funds through judicious use of said funds. And then the unethical example would be misusing public or school-related funds, failing to account for funds collected from students or parents, commingling public or school-related funds with personal funds or checking accounts. Don't put the school's money in your own account. Make sure if you are counting money, you have at least 2 or 3 people counting with you. Make sure that all bases are covered because you don't want to be put in front of a court for stealing money from the school system. Standard 7. Remunerative conduct. An educator should maintain integrity with students, colleagues, parents, patrons, or businesses when accepting gifts, gratuities, favors, and additional compensation. An ethical example of that would be educators participating in ongoing professional development individually and collaboratively to promote student learning. Additionally, they share their knowledge and learning experiences. Mentoring, that's another example. I think we used that in one before, but basically they kind of go hand in hand. An unethical conduct that would be failure to provide appropriate supervisions of students, physical, verbal altercations with colleagues and students, violation of test security for district and standardized test or test materials. Standard number 8, the maintenance of confidentiality. An educator should comply with state and federal laws and local school board policies relating to confidentiality of student and personal records, standardized test material, and other information covered by confidentiality agreements. Once again, we can talk about records and stuff and who has access to them, FERPA, different things. But an ethical example of that would be keeping in confidence information about students that has been obtained in the course of professional service unless disclosure serves professional purposes or is required by law. Maintaining diligently the security of standardized test supplies and resources. An unethical example would be sharing confidential information concerning student, academic, and disciplinary records, health and medical information, family status and income, and assessment testing results unless disclosure is required or permitted by law. Violating other confidentiality agreement required by state or local policy. And standard number 9, hopefully none of us would ever abandon a contract, but abandonment of contract. An educator should fulfill all of the terms and obligations detailed in the contract with the local board of education and educational agency for the duration of the contract. Examples of ethical conduct with this would be know the professional behavior of educators and perform duties within the guidelines that protect the health, safety, and general welfare of students and educators. And an unethical conduct will be abandoning the contract for professional services without prior release from the contract by the employer, refusing to perform services required by the contract. Basically, this is kind of like if you just quit in the middle of the school year because you're stressed out or you're tired or you can't handle it, it's not okay. That's abandonment of contract. I think different things can happen. I think they could take it to the State Department and they may take years off of your teaching certification, different things along those lines. Now, if you put in a notice and then that school district releases you from that obligation, then that is not considered abandonment of contract. Job. And our references came from Nathan Ethics, and he had our classroom book, which was School Law and the Public School, a Practical Guide for Educational Leaders. Thank you.